Hello, everybody. This is Salil Tripathi again for the Institute for Human Rights and Business podcasts. And today I have a very good old friend, John Sherman, who is a senior counsel and who has been helping the International Bar Association develop their new practical guide on business and human rights for business lawyers and the reference annex for the practical guide. John, welcome to London.
Delighted to be here.
A very simple, straightforward first question. What is the purpose of the guidance?
Well, the purpose of the guidance is essentially to enable lawyers to best serve the interests of their clients by understanding the profound implications of the UN guiding principles for their practice in many different areas. Even though it is a combination of hard and soft law, lawyers have a real opportunity to advise their clients on matters that, if they don't take into account, can have very serious consequences.
Now, you mentioned the hard and soft law, and I have a question that's related to what one of the panelists was speaking about today. That soft law is basically what's ethics, which will become legal later, and it will become hard law. So, is it more of an anticipatory exercise? Is that what drives the legal for law firms to look at this more seriously, or is there what you also said, and which is what I want to push and probe a little bit on, the moral agency of a lawyer?
Well, I think yes and no, to be lawyerly about this. I think that in some cases the soft law principles can be laws in waiting, but John Ruggie was very careful to not to reduce the concept of human rights due diligence to a legal checklist that is valuable only for litigants to either use as a sword and a shield, because he felt that it's really critical that the guiding principles have and specifically human rights due diligence, be sufficiently flexible to give businesses in many different sectors the ability to deal with a multiplicity of challenges. So, yeah, they can be laws in waiting, but that's not the only point of relevance to lawyers. And to just give you an example, a lawyer who is advising his or her client on technical compliance with a financial transaction. If that transaction passes technical legal muster, but otherwise opens the client to a tremendous amount of public criticism, government investigation, etc., the client will be very unhappy with the lawyer if the lawyer fails to advise them against that minefield. This is pre-guiding principles.
Right.
You apply the guiding principles now to the area of context. Now, it's valuable context, whether or not it's already embodied in the law. And this is where I think lawyers do have moral agency. I worked in an in-house environment, and it was not a situation in which I had nothing to say about the rightness or wrongness of a particular action. In-house lawyers know this because they are part of the management team, although they also have independence. And so, yeah, I think that lawyers do have moral agency. They don't check their ethics at the door when they go into the law firm.
Now, in that context, how do you see the entire discussion around the treaty? Because some of the critics of the treaty that is being discussed on business and human rights, they see that this is a way to bind down corporations. This is imposing direct liability onto the companies, and this is because there is deep distrust of the corporation, that they cannot do it by themselves, that we cannot leave it to their own, let's say, values, human rights policies, to make this into a situation where human rights are widely respected.
And I think that the best way to answer that is that companies have to deal in real time today. And the negotiation of a binding human rights treaty is going to take time measured in decades. So the question is, what do companies and their lawyers do in the meantime? This is going to be a very long meantime. So there are no silver bullets. Access to remedy is critical. The law and holding companies accountable under the law is a critical part of the guiding principles. So there's no one answer, no silver bullet. Right now, we are faced with many companies having to deal right now with problems in the absence of an overarching binding obligation. So we're not purporting to answer all of the questions here, but we are trying to give lawyers who have influence over their clients the ability to deal with these questions now.
One question I have is about the IBA itself, with which you're of course closely associated. To what extent is this debate going beyond the bubble of the New York, Geneva, London, Washington nexus, as it were? To what extent is it that people beyond this are also taking it, both in terms of law firms and companies, that they should be? Because of course the guiding principles apply in every context, everywhere, and all the time.
Well, what I think it's symptomatic, here's one way of answering the question. It's symptomatic of the legal profession that their impact goes beyond the boardroom. I'll give you an example. At the early part of his mandate, as he was developing the Protect, Respect, and Remedy framework, Marty Lipton, who was one of the top Wall Street lawyers, came out and said, private letter to public letter to his clients, look, what Ruggie is doing is awful because he's trying to usurp the role of the board and impose on them duties that they shouldn't have. So we engaged with him, and after about a year, he turned around 180 degrees and said, look, this is an appropriate way for companies and boards in particular to manage their human rights risks. So when that happened, that was sort of pulled a cork out of the bottle, and then enabled lawyers who advise boards and boards who oversee management, executive management, and management who oversee operations to say, my gosh, we need to deal with these risks. And before, it was basically an issue for companies of, it's not my problem what happens in the supply chain. I'm not responsible for that legally, or if I get sued, I turn it over to the defense lawyers. And now it percolates out into the field and into operations. So I think it does have the potential to spread beyond the confines of the usual suspects who talk about these issues to companies and to boards and to their executive management and to their operations people, which is the people who are making decisions.
So in the ultimate analysis, you're still optimistic?
I'm optimistic. I do think that there's a huge path ahead. I think that law firms are at the very beginning of trying to wrestle with these issues, and there's, they tend to see it as, well, there's, the guiding principles are laws in waiting. Let's wait for the laws, but to be enacted. But I think that the more progressive law firms understand that they have to deal with the guiding principles today.
Right.
And I think that the more progressive ones understand that they have moral agency, that they are their own, they are business organizations, and consistent with their professional responsibilities, they too must respect human rights. I think it's inevitable that this is going to happen, but we are at the very, very beginning of this.
Thank you very much, and I share your optimism. Thank you very much indeed, John. All the best. Yeah.
A pleasure.